Hey everybody, welcome back to my front porch. It is Monday, April 13th, and welcome back to another edition of our coronavirus era Political Science 101. Today I'm going to talk about the Dred Scott case, Dred Scott versus Sanford, one of the most important cases in the history of the United States. Before we get into that though, I want to address a couple of questions that folks had over the last lecture, and I'll just go in order here. A couple different folks posted these things, and number one, someone asked, was the Eighth Amendment at play in Bill Cosby's trial, where he was convicted of sexual assault and some other misconduct? And the answer is yes and no. Really, the type of things that I think you're asking about were related to the Sixth Amendment, and there's a very good chance that I did. If I in any way conflated the Sixth and Eighth Amendment when talking about them, I apologize, but they're so closely related that they are at play in several cases like that. What I mean by cases like that are ones in which the defendant, the person accused of the crime, is so well known that it makes it very difficult to find a jury of people who are not familiar with the facts of the case before the case begins. And also cases that involve some sort of bias, be it racial bias or be it bias towards the type of crime alleged in the trial. So to revisit the Sixth Amendment a little bit, the Sixth Amendment says that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. In the Bill Cosby case, his attorneys made several motions in the pretrial part, meaning the part before the trial begins, after the indictment, before the trial begins, and related to legal issues, not factual issues, but legal issues around the case. And Bill Cosby's attorneys made motions asking for a couple of things. I know for one thing they asked for a change of venue. The issue in his case, and not unlike the O.J. Simpson trial, is that, number one, in the defendant's favor, as far as favor meaning change of venue, the defendant's argument about having the trial somewhere else because the defendant is too well known in the district where it occurred, is that Bill Cosby's case was a state trial. It was about crimes committed in Pennsylvania, and so the state of Pennsylvania was trying the case. And so the question is not just, is there any part of the United States jurisdiction where people would be less biased, or would have less knowledge of the case, or be less aware of who Bill Cosby is and about his career as an entertainer. But we're in Pennsylvania, and I think that was a big problem. And so the judge in that case denied the motion for change of venue. Bill Cosby's attorneys also filed a motion to have a more diverse jury, to have a jury that would be more diverse and reflective of the district of Pennsylvania where it was located. And the judge granted that motion. I don't know the final makeup as far as race and gender and age of that jury, but I know that the judge in Bill Cosby's trial denied the change of venue motion, but granted a motion to have a diverse or more diverse jury. So I believe, I have not read the judge's opinion, but I believe, as I recall, that was related to the Sixth Amendment. Now, the language of the Eighth Amendment, though, has to do with cruel and unusual punishment. And in Bill Cosby's case, I profess my ignorance. I do not know. I can research it before the next lecture, but I do not know whether or not there are any motions about cruel and unusual punishment. But that would have been at the end of the trial, after he'd been found guilty. not the beginning of the trial, and that's where you bring in that change of venue and diversity of the jury, because it has to do with a public trial by an impartial jury. And those are the somewhat controversial parts of cases like that involve any kind of celebrity or involve a jury that may potentially be biased in some way or another. Another student asked about impartiality, which as relates to the Equal Protection Clause of the 14th Amendment, and how, for example, some people, many people in this country, have to face trial with a public defender, while some have very well compensated, very good, by good I mean very effective attorneys with a track record of either getting their clients acquitted or getting their clients less prison time than they might have had otherwise. That has to do with our economic system in this country and most of the Western world. That is an issue of capitalism. Now, I'm not a socialist, and I'm not here in this class or on this lecture to rail against capitalism. In fact, I have many capitalistic tendencies myself. However, there are inequities that you'll see anytime you have a system in which two people can be accused of the same crime, but one person has the resources to pay not only the best attorney that the money can buy, but a whole team of excellent attorneys. And another individual accused of a very similar or the same crime does not have those resources and ends up with a public defender. Now, I am not disparaging public defenders in general. When I was in law school, I spent a summer interning for the public defenders in Hopkinsville, Kentucky, and I tell you, some public defenders are so good at their jobs that they could go on to private practice and make a lot of money, and they choose instead to work for lower pay, defending people who have very little financial resources. The biggest issue with public defenders versus a highly compensated private attorney or a team of private attorneys is the amount of time and brain power that the private attorney has to spend on an individual case. I don't know the numbers now, but about a decade ago in Kentucky, there were a couple of different jurisdictions where the public defenders would have 400 or 500 cases each, outstanding cases at any given time. That is far too many cases to expect them to be able to do their jobs to the best of their abilities. These are attorneys who often would have the ability to represent their clients competently if they had if they had the time to do so. We all have a constitutional right to be represented by counsel, and over the years the Supreme Court has decided that just means competent counsel who's able to do what is necessary to make sure their clients' rights are looked out for during a trial, and that they have competent representation during a trial. But there's no doubt that a defendant like Harvey Weinstein, who has vast financial resources, can hire a team of highly compensated attorneys who can dedicate lots and lots of their time to his case. Whereas someone accused of a similar crime to Harvey Weinstein that he's committed would not have the money to do that, or access to money. Sometimes it's about having cash, sometimes it's about having the ability to liquidate assets and somehow find a way to pay your attorneys. We are in a system where people are compensated so differently for different jobs and different skills. That brings me to the O.J. Simpson case and the same question about that one of you posed about equal protection and representation in court. You mentioned O.J. Simpson, and in the Trayvon Martin and Zimmerman, the defendant in the Trayvon Martin case. And first, I'll mention O.J. Simpson and how at the time of his criminal and civil trials related to the murders and wrongful deaths of Nicole Brown Simpson, and Ron Goldman, O.J. Simpson had more money than the average person. He had more money than me, and I'm guessing more than y'all in the class. I don't know your personal finances, but I'm guessing he had more resources than any of us watching this video. Why was O.J. Simpson a rich man? Well, because he was an extremely good football player. And we live in an economic system in which some people are more compensated for being good at their jobs than others. And I mentioned before that I have capitalistic tendencies. I'm mostly a capitalist myself, and I tell you, I'm a football fan, and I know that football makes a lot of money, more so now than it did back in the 1970s when OJ was the best running back in the National Football League. And I do believe that if you, as an individual, are generating or are directly responsible for generating big sums of money for your employer, you should be compensated. You should be paid for what you've done, for the things you do that makes your higher-ups a bunch of money. And he was. Whether he was justly compensated as a football player, I don't know the economics of that, but I know that he had a lot of money because he was a very talented athlete. And not only talented, but he also worked hard. And he was the best running back in the NFL for several years. During and after his football career, he was involved as an actor in different movies and TV shows where he made money there as well. And so he had the ability to hire a who's who of defense attorneys. He had attorneys on his team that were some of the best in the history of the United States. He had F. Lee Bailey on his team. He had Johnny Cochran on his team. He had a man named Kardashian, who I guess today is best known for being the patriarch of the Kardashian family. But he was an attorney and a friend of O.J. Simpson's. All these attorneys cost lots of money, big piles of money, and O.J. Simpson had the ability to pay them. Would he have been acquitted and found not guilty for that murder, those two murders, had he not had those attorneys? I don't know. I'm guessing, given the evidence against him, probably not. But I am not an expert on criminal law and on the prosecutorial process of homicides. With that, you also ask about Zimmerman, about Trayvon Martin's case. Okay, as someone who believes in the Constitution, I don't believe in the way that it's always been enforced consistently and inconsistently over the years, but I do believe that every defendant is entitled to a fair trial under the law. And the problem with Zimmerman, the man who shot Trayvon Martin, shot and killed Trayvon Martin. The problem with that case is that Florida had what's known as a stand your ground law, and Kentucky has a very similar law, by the way. And I really don't think that Zimmerman violated the law. Now, did he profile a young black man, or a teenager, a black man, a young black man, a boy, and follow him and confront him and initiate a confrontation with him because of his race? Based on things that Zimmerman has said since then, probably. I'm inclined to believe that Zimmerman is a racist. And I'm not a judge and I'm not a jury member, so I can have my opinion without looking at the law, without giving him due process. And it seems to me obvious that he was a racist individual who identified and followed a black teenager because Zimmerman didn't think that person of that color should be in that neighborhood at that time. It's a tragedy. It's an absolute tragedy what happened there, because there was nothing in Florida state law to convict Zimmerman for his racist beliefs and his racist actions. But that is one of many inequities under the law. What's important to remember is that a defendant in a case, in a criminal case, whether it be Mr. Zimmerman, whether it be O.J. Simpson, or whether it be an 18-year-old black man who's pulled over in West Louisville for possessing a bag of marijuana, that those three individuals all have the same treatment under the law, no matter how different their crimes are, their alleged crimes are. Trayvon Martin was a tough case for this country, and I wish we, the people of this country, had paid a little bit closer attention to the implications of it, and had sought to undertake reform under the law, particularly as it comes to how we Americans who are entitled to the Constitution to own firearms, how we choose to use those firearms. I myself am a gun owner. I have had a concealed carry permit in the past, and in Kentucky today, you actually don't need a permit anymore. You can carry a concealed firearm if you legally possess a firearm without a permit. So I myself am a handgun owner. I myself have carried handguns concealed, but I've never racially profiled someone and used the handgun against them. There are a lot of things we need to fix in our law, but one thing that the law cannot address is how we feel about each other. Politicians can address that in ways, and they have in the past, but not through the creation and enforcement of laws. I'm sorry, enforcement, yes, but not through the creation of laws. Not through the creation of laws. And that's one of the most difficult things to grasp about American government and politics, is how we, as a people, view each other. And that has everything to do with the law, but it is not dictated by the law. So, moving on from that difficult topic, I'll move to a different difficult topic. Very important, but very difficult to discuss. And that is the Dred Scott decision, what history is called the Dred Scott case, the Dred Scott decision, or sometimes people may just reference it as Dred Scott. Dred Scott was a man who lived in the 19th century, in the 1800s, and when you hear people say Dred Scott or the Dred Scott decision, they're talking about a United States Supreme Court case from 1857. Case Dred Scott versus Sanford. Dred Scott was a man. Now, sometimes when I talk about this, I say Dred Scott was a slave. Yes, he was a slave. But first and foremost, he was a human being. He was a man. He was a slave. He was a person of African descent. And he was a slave in Missouri. Missouri was a slave state. I mentioned on previous lectures that Missouri was kind of complicated because, like Kentucky, Delaware, and Maryland, Missouri was a Union state in the Civil War. Missouri slaves were not freed by the Emancipation Proclamation in 1863. They were freed by the 13th Amendment. But Dred Scott's case came to the Supreme Court in 1857. Dred Scott, again, was a slave in Missouri. His owner took him on a trip with him into free territory, a territory that was by law free, where slavery was not part of the law there, where you could not purchase or own rights to people of African descent. Took him to a free territory and then back to Missouri, the slave state, and Dred Scott filed a lawsuit saying that when you took me into the free territory, I became free. And just because you brought me back to the slave state of Missouri doesn't matter. I am now a free individual. The case lost in Missouri State Court, so it was appealed to federal court. Dred Scott lost its case in federal court, so the case was appealed to the United States Supreme Court. Now, at that time, the Chief Justice of the Supreme Court was a man named Roger Taney, spelled Taney, but pronounced Taney, like there's a W in there. There's not, but Roger Taney was originally from Maryland. He grew up in a slave state, and he was the Chief Justice. He was the head of the United States Supreme Court, and de facto head of the United States federal judicial system. So, on the question of whether or not Dred Scott became free when he became a free person when he crossed from Missouri into a free territory, Justice Taney said no. He said that he needed to apply Missouri law and under state law. Dred Scott did not become a free person. He could have stopped right there. But some of the worst and some of the best cases in the history of the Supreme Court have a habit of not knowing when to stop, meaning the court just kept on writing, I should say, an opinion when it could have stopped with the current law. If Justice Taney had said, "No, sir, you are not free because you crossed into a free territory," and just stopped right there, it still would have been a major blow to the anti-slavery forces, both black and white, in the northern states in 1857. But he kept going. And I want to point out a couple of excerpts here, and I will say that whenever necessary, I'm going to say black people or a black man as opposed to the terminology used in the 1850s. And keep in mind, this is 3 years prior to the outbreak of the United States Civil War, the election of Abraham Lincoln, and the secession of the southern states that led to the Civil War. And also keep in mind that the Supreme Court, by a 7-2 decision, Taney and 6 other justices agreed with his opinion, 7-2 majority. They really thought that they were going to put to rest the controversies around, the legal controversies around slavery, around slave versus free people, and the right of southern states to, people in southern states to own human beings and to force people into servitude. They really thought they were going to make the kind of difference that would quiet all the whispers of civil war between the North and South. They in fact did the opposite. So Justice Taney wrote this. The question is simply this: can a black man whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all of the rights and privileges and immunities guaranteed by that instrument to the citizen? Now, see what Taney is doing here is he's talking about whether or not Dred Scott even had the right to sue his owners in the first place. As a slave and as a person of African descent, can he even file a lawsuit? And here's what Taney said. We think that black people are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority and had no rights or privileges, but such as those who held the power and the government might choose to grant them. This is huge in a very, very, very bad way. Because and I'm not reading anymore, this is my opinion, what he's saying in this Supreme Court opinion is that black people, whether they were free or slaves, did not have the rights granted by the Constitution. Remember, I've told you many times, both on YouTube and in person in class, that the rights of the Constitution apply to all people in the United States, whether they're citizens or not. This is the opposite end of that spectrum. Taney is saying that these rights don't even apply to free black people in the United States, much less slaves. Tawney said that perpetual and impassable barrier was intended to be erected between the white race and the one which they had reduced to slavery. This is some of the nastiest and worst language in the history of the Supreme Court. He went on to say, "It is difficult at this day to realize the state of public opinion in relation to that unfortunate race, which prevailed in the citizen and enlightened portions of the world at the same time of the Declaration of Independence." Now I'm going to skip ahead a little bit. They had for more than a century been regarded as beings of an inferior order. So, again, what he's saying here is that black people, regardless of free or slave, are quote-unquote inferior and not entitled to the rights given them in the Constitution. And now I'm reading his opinion again. And so far inferior that they had no rights which the white man was bound to respect, and that black people might justly and lawfully be reduced to slavery for his benefit. That's what he said. Reduced to slavery for his benefit. Tawney was regurgitating, and now I'm done reading. This is my opinion again. Tawney was regurgitating things that slave owners and politicians from southern states had been saying for decades by the 1850s, that it was for the benefit of black people that they be enslaved because they weren't capable of governing themselves and taking care of themselves and looking out for themselves, which is about as racist as it gets. The idea that that one race is so inferior to the white race that they can't take care of themselves. It's I mean, this is beyond offensive to the 21st century ear. This is part and parcel of modern day white supremacy. This is the worst of the worst of thinking. This is the worst of rhetoric when it comes to people of color and people of African descent. And this came from the Chief Justice of the United States Supreme Court in 1857. So, I'll conclude with this. And if I'm smirking or if I'm smiling, I don't think this is funny. I think this is so uncomfortable to talk about that sometimes I smile or chuckle out of amusement of how stupid and dense some of the white people who ran this country were in the 1850s. This is such a difficult case to read, and I encourage you to read it. If you look up online, Dred Scott, Dredscott versus Sanford. Dred Scott versus Sanford. Read the text of it. It's a long opinion by Justice Roger Taney, and it's hard to read. It's hard to look at, and it's hard to even talk about. But it's very important. It's very important for a couple of reasons. Number one, it put into the law by way of a judicial opinion, these racist beliefs of southern state governments and state government officials in the days leading up to the Civil War. That's number one. And the second reason is that, as I mentioned earlier, the Supreme Court really thought that they were going to quell some of the whispers of civil war in this country. And what they did instead for the northern states was inspire people who had earlier been passive or a little lax on their anti-slavery beliefs to stoke that fire and to wake up people, both black and white, but especially white people up north who had thought, oh yeah, slavery sucks, but we're not sure how much we want to get into it. We're not sure if we're willing to fight and die for it. When the Supreme Court issued the Dred Scott decision, and the law said all the things I just read to you about the quote-unquote inferiority of one race as opposed to another, a lot of people up north were angry. They were beyond angry. They were furious. They were ready to fight. And I really don't think that Abraham Lincoln is elected president in 1860 if it's not for the Dred Scott decision, for the Supreme Court's god-awful attempts to settle the issue of slavery and the controversies around slavery in the United States by saying that black people weren't people. That's what they said. They didn't say it in those words, but that was the legal effect of the Dred Scott decision, that black people were not the same kind of people as white people. And up north, people were furious. And this was the next presidential election after the Dred Scott decision was the one in which Abraham Lincoln was elected president. And upon his election, states began seceding from the Union, leaving the United States, or trying to. They never legally did, but they tried to leave the United States, and they began a civil war for the autonomy of the southern states as opposed to the northern states. So this is an incredibly significant piece of history, and the United States government and our current politics would not be what they are today were it not for this god-awful opinion written by Justice Roger Taney in 1857, and for the fallout of it, the backlash from it. The backlash from it was unprecedented in U.S. history. Never before had a Supreme Court decision been so controversial. Well, there have been controversial cases, but not quite this controversial. So, if you have questions, thoughts, or comments about this, please post it below or email me or text me anytime. And don't forget to comment below the video that you watched the video, that you saw it, and that's how you get your participation grade for today. If you have any questions about your grade so far in the class, I've finished the last quizzes and I've emailed a few of you either your current grade or that I didn't get the quiz, which could be your fault, could be my fault, and either way I'm working to address those things right now. But if you want to know your current grade, or if you have any questions or thoughts about this, email me, text me anytime, and comment below that you watched the video. Thank you for hanging through this video of some difficult subject matter today. Difficult, but highly important. And hope you all having a great week. Hope you're staying socially distanced. I hope you're staying safe. And I'll talk to you all on Wednesday.